So, hello everyone. I'm Professor Shlomit Yanisky-Ravid. I'm a visiting professor at Fordham Law for many years, 12 years already, and a professor fellow at Yale Law School at the ISP for 14 years. I'm the head of the Graduate Law School of Commercial Law, High Tech and Technology at Ono Academic College for a few years, and I'm a senior faculty at Ono Academic College, Israel. I'm also the founder and the head of the Shalom Institute of Comparative Research Law, and the center, which is part of the Shalom Institute, which is the Eliyahu Law and Technology Center. And I'm here to speak about IP in general, and more specifically about copyright. And we will focus on copyright on United States. I might say some words about other jurisdictions, but mainly on United States. I worked with WIPO. You can see the WIPO logo over here. So I worked with WIPO, which is the World Intellectual Property Organization, for many, many years. In collaboration, and a lot of things that you'll see here, it's also part of the collaboration with the world most significant organization for IP in general. And you know, IP includes patents and trademarks and designs, or what we call here patent designs. But here today, we are going to focus on intellectual property within the copyright regime. So let's begin. Okay, so the most fundamental article that you have to remember and to memorize is Article 102 of the 17 U.S. Code. 17 U.S. Code is actually the copyright law, the Copyright Act in the United States. And let's go to Article 102. You can see it here on the slide. So copyright protection subsists in original works, which is very important, we'll speak about that in a bit, of authorship, fixed in any tangible medium of expression, now known, later developed, but these are the most fundamental part of this article. And then you ask yourself, okay, what is a copyright? I mean, what is copyrightable work of art? So I want you to take like 1 minute and just to write down like 10 examples of copyrightable works you can think about. It shouldn't be patent, it shouldn't be design, it shouldn't be trademark, it should be copyrightable works. So, okay, let's take a minute, write it down. So I hope you had in this list that you just wrote down, I hope you had stories and melodies and films and videos and sculpture, and even it can be like a movement of dancing, or it can be like architectural, or it can be many others form of works of art that you can enjoy. So I hope you had everything in the list and you had like 10 on your list. But then you ask yourself, okay, you wrote a story, you wrote a plot, you composed a melody, or you did some drawing. So what do you have actually? So what are the rights that you are holding by exposing that work of art to the world? So owner's right also included in 17 U.S. Code, which is the Copyright Act, Article 106, and he said you have the right to reproduction, to do derivative works like translating your story or making it like a Broadway show, distribute it, to do public performance, like to sing in public, public display if it's a painting, to put it in an exhibition, or any transmission. Like derivative works, as I said, it's kind of like still your ownership as an author, and someone who is translating your story into other language, doesn't mean which other language, would be considered wouldn't be considered as the author, because the original author has to give license, permission to someone to translate the work or to transfer it into a play or plot, and the original author keeps the copyright over the works of art. So one question before we move forward. What would be about software? Is software copyrightable? And the answer is yes. So software has this kind of like industrial feature, but when it first came out, like more than 100 years ago, so like the International Institute thought, how can we define software? And say software is just a language. It's like it's French or English or Chinese or Hebrew or German. And it means it just goes by computer language. So they kind of like classified software under literature works that is part of copyrightable works of art. And sometimes it doesn't match perfectly to this definition. So there are some exceptional limitations, like about the duration or about moral right. But at the end of the day, it's copyrightable. In some instances, and like in the exception part, go to Alice, it can be also considered as a patent. But the main and the traditional way of looking at software is as copyright work of art. Okay, so let's go to Article 102, the subject matter. Okay, so first we have original works. So what does mean original? So original means that you didn't copy it from any other source, like it came from yourself with your creativity. But for that, let's look at the most important core decision that everyone must know. It's really a must. Like being aware of face publication, even if you're not going to be an expert in IP and in copyright, still face publication is one of the most fundamental court decision. And let's hear the Supreme Court how we interpret originality. All right, so we'll hear the opinion. It's not a new one, but it's the most fundamental one. So the opinion will be heard. You can hear it. You can see it here.
The opinion of the court in number 89-1909, Feist Publications Inc. versus Rural Telephone Service Company Inc. will be announced by Justice O'Connor.
By Sandra.
This case comes to us on certiorari to the Court of Appeals.
So the case comes to court about protection available to telephone directory white page. So the respondent, Rural Telephone Service Company, is certified public utility providing telephone service to several communities in Kansas.
State regulation, it
and
publishes a typical
after
telephone directory
state regulation, it publishes a typical telephone directory consisting of telephone numbers and locations to covering large areas. So now, when Rural refused to license its white pages listing to Face for directory covering 11 different telephone services areas, Face copied them without permission. So Face copied 1,300 listings without permission. So Rural sued for copyright infringement. So the United States District Court for the District of Kansas granted summary judgment to Rural, holding that the telephone directories was copyrightable and therefore they infringed the right. The 10th Circuit Court of Appeal affirmed, and so the 10th Circuit, as I said, court affirmed. And in the opinion that was given by the Supreme Court, they reversed. And they explain that the fundamental principle of copyright law is, in fact, are not copyrightable. So, again, the fundamental principle of copyright law is that facts are not copyrightable. That is because, let's continue, That is because,
this is because as a matter
of both constitutional and statutory law, a work qualified for copyright protection only if it is original. And original, as that term is used in copyright, means that the work was independently created by an author and that it was possessed at least a minimum amount of creativity. So let's repeat that because it's really, really important. Original in copyright, as the term is used in copyright law, means that the work was independently created by the author and that it possessed at least some minimal degree of creativity and not just work. So let's go on. No one may claim originality as to facts because facts are not created by the author. They are merely discovered and reported. Okay, so facts are not considered original. Originality from the author. So they merely consider as facts that someone found somewhere as a discovered work. One may, however, claim originality in the way facts are selected, coordinated, or arranged. These choices by the author, so long as they entail some minimal degree of creativity, are sufficient to create originality and to grant copyright protection.
Selected, coordinated, or arranged.
So we conclude, it means the Supreme Court concluded in this case that faced by taking 1,300 listings from rural white pages did not copy anything that was original to rural. The bits of data contained in the listing are uncopyrightable facts because they were facts that were not created by original author. Rural didn't select, coordinate, or arrange these facts in an original way. Rural selection and arrangement were obvious. The list is alphabetic by names and subscribers, town and telephone of each of its subscribers, and this is frequent and age-old practice, so commonplace that it has come to accept as a manner of courses, because rural white pages are devoid of creativity. Face did not violate the copyright laws by copying them. And the opinion, joined by eight members of the Supreme Court, Justice Blackmun concurs in the judgment. All right, so we understand that originality means comes from someone's and with like a minimum amount. We usually look for more than minimum amount after face of creativity and not just hard work or like facts and other things. So that's for originality. When we speak about expressions, so what should be understood as expressions? So it can be literature and artistic expression, architecture, software, drama, music, everything that was you listed in your list. Visual arts, sound recording, video games, computer software. So expressions, we understand expression versus idea. It's not just an ideas in the air, but it's something that was expressed in the external world, because we cannot know what's in someone's mind. I mean, maybe with Elon Musk Neuralink project, we will be able to download thoughts, but we are not there yet. And for now, we distinguish between expression and ideas, and copyrightable and Copyright Act can be acting out only on expression. And we need tangible medium of expression. Like there is the idea, like I want to write a book about a child that goes to, I don't know, some weird places, and maybe he's a magician, remind you of somewhere. And but it's not the idea. that is protected. Is kind of like the fact that it was written and expressed in a certain manner, and this certain manner cannot be copyrightable. So everyone can write about different expressions of child that wants to become a magician, but just Rowling has this specific expression that she holds copyright on. But there are still exceptional limitations to copyright. And there are some things that are public domain. There are facts that are not considered copyrightable. And there is the exception of limitation of fair use. So why do we have these exceptional limitations if we want to give the author the rights over the works of art that he created or she created? So we have like two conflicting rights. One is and that stems from the Universal Declaration of Human Rights. So let's look at two sides of Article 27. One said yes and one said no. So the Universal Declaration of Human Rights, Article 27, says that the right to the protection of the moral and material interest resulting from scientific, literature, or artistic production of which he or she is the author. So we want to grant right and protection over works that were created by the author. On the other hand, the same Universal Declaration of Human Rights, the same Article 27, states about access to knowledge. But he said, but everyone has the right to freely participate in the cultural life of the community, to enjoy the art and to share in scientific advancement and its benefits. So on the one hand, we have the right of a holder to be the owner and to exclude others of his work, at least for a limited time. On the other hand, we want all the world to have access to knowledge and access to art. So how can we balance between these two rights of everyone to have access to rights, access to knowledge, access to culture, and the author's right to exclude others? So we have a few mechanisms to balance between these two protected rights. One is eligible patent matter, so not everything is copyrightable. It's similar to that, not everything is patentable. So we have eligible patent matter, eligible subject matter, eligible copyright matter. So we have like definition what can be considered as intellectual property, and then someone gets the right to exclude others. And then we have exception and limitation, like fair use or compulsory license in patent law. So that's also like, okay, that's kind of like balance between the right of the public and the right of the authors. And the third mechanism is that to have limited protection. For IP, we have limited protection before it becomes public domain. So these are the three mechanisms you have to remember. So if we'll go to copyright again and to the American regime of copyright, so we have 4 factors. And these factors are guidelines that courts are free to adapt to particular situation on case-by-case basis. So these 4 factors means like someone can have a copyright over a song, over a video, over a film, over a painting, but someone else is copying that. But he can defend himself by getting this exception limitation that is considered as fair use. So what are the 4 components, 4 factors of fair use? The first one is the most dominant one, is the purpose and the character of the use. The use that, like the copy, the works that copy another work. So we call it transformative, and we have to ask the question, is this creation, it's a creation of someone, or it's new, or it was just copied from and into another work? Or we ask ourselves, some other question, was the copyright work transformed by adding new expression of meaning? Was value added to the original by creating new information, new aesthetics, new insight, and new understanding? And the second one, still in the first factor, is parody. It means like critical commentary on original works that comes with some critics about the work and some social critic about the work. So we have the song of Barbie that kind of like some other group, some other band copied the song, but kind of like critic the high upscale blonde girl that has beautiful life, and that was considered as fair use. We have the story of Gone with the Wind, where the white people were the lords and the others were like people of color were the servants. And there was another story with the same plot but changed the races, like who become the lords, people of color, then who become the servants. And that was also considered by court as a fair use. And we have a lot of other examples. So the second factor, the first one, as I said, is the most important one, transformative. You have to remember that. The second one is the nature of the copyright work. Like if we speak about like academic work or book of history, so the law is more flexible in having that distributed or cited. Then if it's kind of like a work that originally the main purpose was to make money, like a movie, Disney movie, for example. Thirdly is the amount and I think the majority, the major part and the importance of this part that was copied. So what kind of portion was taken? Is it like the major part or the important part, or it's kind of like above? So that's also something to consider. And the fourth is the effect of the use upon the potential market, and it includes also the minimum. Like the minimum effect. So let's take, for example, like this book about Gone with the Wind, which became a very, very famous film in the former century. And then like the new book actually raised the sales of the old book. So sometimes, even if it's kind of like copied in a way that align with the factors, so it may raise the sales and make the original author makes more money of some neglected work. Sometimes and sometimes not. So it's also that four factors. So the purpose and the character of the use, the transformative, the parody, the nature of the copyrighted work, the amount of the importance of the portion taken, and the effect of use upon the original work, of the market of the original work. So that's about fair use. And we'll say a word about the justification for copyright in general. So we have like four main justifications for copyright, and they are aligned with other justification for patents and other fields of intellectual property. So firstly, we have the law of economics, which is the major and the dominant theory in the United States. And we would like to give incentives to authors to create works and to publish their work, to give their work to the public. So Professor Posner was speaking about some contract that the society, that the public makes. Of course, it's been artificial by the law, with the author, where the public said to the author, you know what, we'll give you for limited time exclusive right over your authorship, and you can exclude others from using that, and you can license it and get money for everyone who wants to use that. And after a certain amount of years, which is 70 years after the death of the author, so it will become public domain. And we're giving it to you because many times copyrightable works are very easy to be copied. And if I enjoy some film that I download without paying, not me, but someone, so I mean, many others can enjoy the same thing without paying the author. So what would be the incentive of the author if everyone can enjoy what we call free riders? Like everyone can become like free riders because copyrighted works are actually public goods. So we are kind of like giving incentives, not for incentivizing the author, just to incentivize him to dedicate more and more works of art to the benefit of all society. All right, so this is the kind of like an efficient way to get more and more works of art and great ones that really contribute to the culture and to science and to progress of art, as the famous article from the U.S. Constitution, Article 8, states. The other theory is the labor theory, Lockean theory, and said each person owns her or his body and soul. And if you create something out of your body and soul without limited the access of others, like you created a song, but like everyone on earth can write songs. You created a painting, so everyone can paint. Like you didn't dilute the capability for doing more and more painting, so you have the right to own your work. Personality theory, the third theory after the law in economics and labor, so we spoke about Kant and Hegel, and we spoke about the property kind of like defines and broadens, defines someone's personality, develops someone's personality, broadens someone's personality into the external world, and therefore we have to respect that and to give them authorship. And we spoke, if we haven't spoken about the personality theory, any other theory, so you'll better read about that, and because it's really an important issue of understanding, important basis to understand copyright patent and any IP laws. So Professor Margaret Radin said, I mean, there is some assets that are replaceable, but there are some assets that are really personal in her theory of property and personhood. And the personal, like if I'm writing something, if I'm authoring something, if I'm a choreographer of some dancing, so it's kind of like my personality that reflects on in the outside world on this work of art. So that's mine, and I shouldn't give it up, and no commercial transaction should be done with that. Usually it's like the civil law countries, as mentioned, like Europe, European country, like France and Italy, Scandinavian country, Germany that holds the personality rights, not just for copyright, also for privacy and other rights, whereas the mostly English-spoken countries, like United States and like Australia and others, they are more influenced by law and economics. And the last thing is distributive of justice that reflects the fact that in each and every work there is like a reflection of many contributors, like the public, other authors, authors of other arts that the author was exposed to. So it's kind of like if we want to make something more egalitarian and justice and fair, so we have to make our policy about copyright under the veil of ignorance, like not just something to incentivize ourselves or our groups, but to incentivize all society. So that's kind of like distribution of justice for more egalitarian, and it also has implication on copyright. So law and economics, labor, personality, distribution of justice, these are the fundamental theories that justify copyright. All right, and we still have to remember that when we speak about the United States law, the U.S. law, so we remember the article in the Constitution saying that to promote the progress of science and useful art, We are incentivizing and giving authors and inventors for limited time exclusive right over their discoveries and useful arts, which is really aligned with the law and economics theory. So let's move on and speak about some ideas which are common to copyright, but not just to copyright, also beyond copyright to patent and other IP fields. So firstly, and we have 8 of them. Okay, so one of the 8. As I already mentioned, we distinguish between idea and expression. There is the idea and expression dichotomy. So it means we cannot copyright just an idea if it's in our mind. Like if I think about something and something in my neurons and synapses inside my head. So, I mean, no one knows that. Just when these ideas are reflected in the external world, so the legal regime can start playing with it, start intervening, start enforcing. Because otherwise, who knows what I have in my mind. So software, novel, architecture, any expression, invention, so that should be reflected into the external world, so copyright regime can comes into play. The second one is fixation. As I mentioned, Article 102 of 17 U.S. Code says the original works of authorship have to be fixed in any tangible medium of expression. So there is the IP in my head. It has an external reflection, external existence. But then it has to be fixed in some tangible material. So maybe it's outdated a bit with all the lasers and all the expressions of AI, but still it exists in the law and we have to respect that. So we can speak about culture, like you can see here, a culture made by Picasso. So it's kind of like the design. Maybe I'll do part of a women's face if it's a women's face, but it's kind of like, it has a fixations on stones, on bronze or whatever the artist chooses. You can see a copy of a Harry Potter book. We spoke about that. So it is a way of expression that is written on a book, on a computer. So computer also would consider like aligned with the fixation criterion. Like software and hardware. So we have like a software, it's a literature works of art, and it's embedded into a hardware. So this is the fixation. So the third is the commercial feature of IP rights. It means that we can commercialize copyrightable works. It means we can sell them, we can license them, we can give them as a security. So we can, but it's more sophisticated even from tangible assets. Like if I have like a house, so, or an apple, so it's either I have it or I don't. I mean, I can sell you my apple, I can send you my, my house, but, or my car, but still, I mean, when I sell it, I can also maybe rent it, not so much about apples, but maybe about houses, so I can sell it, I can rent it. But here, when we speak about copyright, like think about melody, so first we can like license a film that we made, or even a presentation, which is also copyrightable, to many people. I can upload it into the to the internet, and thousands of people, even more, can download that, so they can enjoy that. So in order to avoid this, as I said, free riders, so everyone has to get a license. So I can license the use of this software because it's intangible, because it's intellectual property. So I can license the copyright in software or in other works of art to many, many, many users. And I can, when I license it, that's for my work at the IBM, So we used to license, like every day I did like 100 license agreements. And every license agreement was, many similar components, but many also different one, like for how much time, how many people can use this software, if they can really transfer it, or what happens if they don't pay. So there is a lot of possibilities, many more possibilities than with the tangible assets to play with commercializing works of art, copyrighted works. Okay, so that was the third. The fourth, we already mentioned that, it's kind of like also a summary. The fourth is having copyright as having patent right. It's a negative right, the right to exclude others. So exclusive right means the right to prevent others from using the IP products to enjoy their fruits. So it means if I'm owning a copyright over a book, so I have the right to copy, to distribute, to perform in public, to sell, to license, to translate, which is a derivative work, and I can exclude others from doing all these things. I can exclude others from copying without payment. We have two things, permission and payment. Distributing it, performing in public, selling it, licensing it, or translating it. Okay, the fifth. The fifth is very interesting, is limited duration. Also, we can understand it by the law and economic theories, because if you think about personality theory, so it should be unlimited, and moral right, which is the best resemblance of personality theory in copyright, means that it's never ending. But if we think about law and economics, so we say the other way around. We said, okay, it's not your personality, just your incentive, but incentive, the main goal of the incentive that we are giving you, this exclusive right, is to give your book to the public, that everyone can enjoy your book. So you have exclusive rights for 70 years after the death of the author, okay, years after the death of the authors, can be extended in specific circumstances, like it happened with Disney in the United States, which you draw a lot of critics from external world. But after these years, forget about it. Your book becomes like public domain. You don't have exclusive rights anymore, and the book and any work of art become public domain, like everyone can use it without two things, without getting permission, what we call licensing, and without being paid. Okay, so copyright is the life of the author plus 70 years. What happens if there are several authors? So it's the life of the second or third or whatever, if you have several authors. So the last one who unfortunately passed away. It might not be fair if some author died in a young age, so the length of protection expires sooner than someone who has a very long life. And we have examples of that, like the Bolero melody. So after the death of the author, there was 70 years passed by after the death of the author, but then some descendant of another person says that he was part of creating the melody, and 70 years didn't pass from his death. A court decision from Israel about Charlie Chaplin was that they used Charlie Chaplin kind of like short the image and part of short part of a movie in a commercial for lottery company. And they thought that 70 years, Charlie Chaplin, that was 100 years ago. No, it wasn't 100 years ago. 70 years didn't pass. And the company that were entitled to the right sued and won. So we have to be careful with using copyrighted works before 70 years since the death of the author has passed by. In patents is 20 years from the filing, and you can see 35 U.S. Code, Article 154. And there is a shortened time for trademarks, and but trademarks can be extended for many more years. Okay. The sixth out of the 8. So we have moral right, what we call droit moral from French, that is reflecting the personality theory. So what is moral right? Moral right is that we should call it, I think, personal right. It's the right of the author to do two things, and it's distinguished from the right, what we call the economic right, to sell, to distribute, to give permission, license to use the work, and so on and so forth. So the moral right contains two main rights. So we have the economic right, the moral right. Now we focus on the moral right, and it has two main rights. In Europe, in France, and other countries, they have more expressions of moral right. One is the right to integrity, and the other one is the right to attribution. So it means that if you wrote an article, so the attribution right, or the fatherhood, it should be the motherhood. So the fatherhood right means that you have to be named as the author. So whenever someone published your book, whenever someone's published your painting or something, so in a reasonable way, it should mention that you are the author. So that's the fatherhood or the attribution. The other right is the integrity right, which means that you created a work of art as a whole, so no one can change it. And like in the United States, the moral right is a very weak right. In Europe, it's very strong right. And in France, we have this example of someone made some series to TV, to the French TV, and the French TV, the commercial channel, want to change one of the chapters, and he refused. And they had a fight in court, and the author won, because integrity means that you have to keep the work of art as it is. Okay, so let's see first in Europe where the moral right stems from. So in Berne Convention, which is the international convention that resembles copyright, so when we speak about the Berne Convention, so we see that independently of the author economic rights, that's what I just explained, and even after the transfer of the said rights to a third person or fourth, it doesn't matter. Even if you sell the economic right, to sell, to dispute, and so on and so forth, the author shall have the right to claim authorship of the work and to object to any distortion, any change, or other modification of the said work, which will be to his honor and to his reputation. So that's very important, and in some countries, moral rights are internal. Other countries, they have like different length of moral right. Like in Israel, they recently changed it and said like the moral right should be as long as the economic right. But you could look at each and every country. What happens in the United States? Because we are focusing today on the United States. So 70 U.S. Code, Article 106, known as the what we call VARA, the Visual Artistic Right Act, was enacted in 1990, and United States didn't like the moral right because it gives much more control to the author. So for almost 100 years, they refused to sign the Berne Convention. At the end of the day, they did some compromise, and the United States did sign the Berne Convention, but with this exception. But it's more right that kind of like contradicts the law and economics reasoning. So they had this VARA Act, the Visual Artistic Right Act, which gives like minimum rights to authors. So the visual art includes who gets moral right, like the integrity and the fatherhood, right to be named in any publication of the work. So you can get it as an author of painting, drawing, prints, sculpture, and photographs. But it's limited. It's existing only in a single copy or limited edition of 200 signed and number copies or fewer. So it means like the unlimited moral right on each and every works of art that is copyrightable in Europe. Here we have only limited edition to first specific categories of art, and secondly just limited edition up to 200 signed and number copies. So in general, we can say that it's really a weak and limited right. The droit moral, the moral, the personal right, and we can understand it if we understand the law and economics justification to copyright. And also, whereas like in Europe, we have copyright and moral right to employees. So the VARA Act, the Visual Artists' Right Act, say there is no moral right to employees. And if you go back to Article 101 in the Copyright Act, the 17 U.S. Code, so the United States did some sort of trick, and they title the employer or the one who paid for creating work of art in specific 9 categories, so employers in general, or the first contractor, the one who paid for some artist to make a work of art or software. So they titled them as the author. So they have the rights, neither the employee or the subcontractor, the artist who actually made the right. And you can go to read the court decision, or alternatively, if you want to read about patent, so there are other Dublier court decision, which is the fundamental one to learn about that. But if we go back to moral right in the United States, so it's really limited, right, and but still it includes attribution, integrity, and the right also to avoid attribution. Like you can I can sign and waive my moral right in the United States, where I cannot do that in Europe. But because of like I would say international characteristic of copyright in general, so it might be there are some influence of moral right also in the United States. Like if you think about some American artists, so maybe it's kind of like they come from law and economics, like their reputation. We want to know that Andy Warhol was the one who created this video or this pop art. So we will give him the attribution because we gain economic benefits from attributing. Or if you can read Catherine Fisk article that analyzed, and also I was mentioning it in my book, analyzing why moral right can exist in the United States from law and economics because of these economic incentives of reputation, and because of like the responsibility, like I know who is the author, so I have the ability to know if it was an original work. So there are some justification you can read in my books or in Catherine Fisk article. I really recommend that. All right. So just to summary before the before the last criteria that we'll go through. So if we address copyright, CR, so we don't have to register that. There is an optional registration, but if we want to go to court, so we have to register it with the U.S. Copyright Office, and we send it to the Library of the Congress. The duration of protection is 70 years after the death of the author. There are some exceptions, but we won't go into that. Like if it's work made for hire, so 95 years from the publication, or 120 years, and the author is the employer, or the first contractor, nor the employee, who is actually the author. And moral right is really limited. If we'll think about the industrial IP, like patent law, so registration process is mandatory. We don't have patent unless we submit the invention to the patent office, and the patent office really issue the patent. That's where the patent came into life. And the duration is 20 years from submitting, after registration, from submitting. And there is no moral right in general in patent law. I claim in my article that there should be, but as a matter of fact, there is no moral right. Like in the United States, you can, when you submit an invention, you can title the right over the employer, and in other countries that follow the U.S. law or follow law and economics, you can title a patent over the employer or the commercial body. All right. So, 7th, registration. Now, in copyright, use protection is automatic. In any other country, once you created a work of art, you expose it like it has like external expression, embedded in a tangible asset. So it becomes copyrightable, but you can protect it, you can submit it to the U.S. Copyright Office and argue that you have copyright, even if you want. It's the United States, I think, one of the sole entities that can register copyright in the whole world. Maybe there are some others, but very few. But registration is required to sue. So if you want to sue someone over infringement of your copyright, so you should go to court. Trade secret, you don't have to, it can last forever as long as it's kept in secret. Patent, you must register a patent in order to get a patent, and trademark is different because you can use trademark, and then after in some criteria, you can trademark, but it's better to trademark it, to register the trademark, because it gives the owner better right and stronger right to sue others. And lastly, it's the international instruments. So we have TRIPS agreement, and we have the Berne Convention. So TRIPS agreement, it's all fields, also on copyright, but mainly on patents and industrial applications of IP. It states what would be the minimum protection. It also claims for anti-discrimination among the different countries, because it's international agreement, now runs by WIPO, the World Intellectual Property Organization. It defines what is software, the duration, and it also suggests dispute resolution mechanism. For patent, you can use the Patent Cooperation Treaty that helps you in some procedurals, but there is no registration of one-click registration in all countries. You still have to go country by country. Madrid Protocol deals with international registration of trademarks and designs and trademarks, and we have Hague for design. We still, and Berne, of course, for copyright, we already mentioned that. We have some other related, what we call the neighbor's right to copyright and to IP in general. It can be freedom of speech, access to knowledge, privacy, internet law, tort law, contract law, unfair enforcement, unfair enrichment, and competition law. If you want to learn more, when that's we are heading the end of this class. So you want to learn more, so there are things that copyright has to do with some other affiliated, very interesting fields, traditional knowledge and genetic resources, traditional culture and expression for copyright, like how can we protect quilling and other traditional way of creating arts by communities that The knowledge went from generation to generation. Should it be protectable? How can we protect that? Of course, it has to be dealt by international organization, and WIPO has a committee that has some achievements on protecting traditional knowledge. Rethinking intellectual property in workplaces. So we have like the European approach where the employees hold their copyright and the moral right. And versus, in contrast, we have the United States where the employer or the first contractor is defined as the author, and there is no moral right for employees. So if you want to learn more, I mean, I have the whole book about that and articles, and you can find it on the web. We have the privacy right that sometimes also affiliate with the copyright. There are a lot of writing about intellectual property and gender. That was one article I wrote, like more than 10 years ago, that women are excluded from having ownership over copyright and over patents. And there are a lot of new articles coming out about that issue. We have the topic of access to knowledge for persons with disabilities, the Marrakesh Treaty. We call it VIP, visually impaired person, and there is an exception and limitation for these VIP, visually impaired persons, to get them access to printed material, because like if you take printed material and transfer it into audio books, or so you have to get a permission from the author or from the publisher. But for blind people or people with it shouldn't be blind, but visually impaired persons and other people with disabilities, there are exceptions and limitations, and you can find it also as part of the United States copyright law. Freedom of association of workers and the entertainment sector versus competition and antitrust laws, also very important issue that align and affiliated and overlap with copyright. The right to moral right, new developments in Europe and in United States. Intellectual property right and freedom of religion. It's also like religion should be free, but there's also some sign that can be trademark or considered copyrightable. Intellectual property overview. The intellectual property should be shaped differently at modern time and digital global era. So here, that's my expertise on the question of when AI generated works of art, and in general, we recognize just currently, I mean, these things can change really rapidly, that there are three approaches that the United States Copyright Office does not recognize and does not grant copyright to works generated by AI work, just to the human contribution. And we have this Davos, where I'm part of the representing Dr. Thaler, who created Davos, which is an AI system that created a work of art, and it didn't get the copyright within the Copyright Office, and now we're in appeal, and we're waiting for the decision. Same thing, we took it to the Supreme Court, and I was honored to submit the brief to the Supreme Court of patent that was generated by Davos by an AI, and that's the American approach. Versus to American approach, we have the European approach to copyright, specifically that like in UK and New Zealand and Ireland and other countries that amended the Copyright Act to add computer-generated works. They said without going into the question of who is the author, but the owner, like shifting from authorship to ownership. So the author should be the one who make the arrangement to the final work of art that was generated by AI. And we do have we can still find, we have some clues for this approach in Disney court decision, where they say the one who made the lion's share should be the author. And we have the Chinese approach, Li versus Liu, which actually interprets repeated and creative prompting as the creativity that needs to create works of art, and granted ownership to the one who prompted the final result of an AI. We have like things about patent law, and we have also some trends in patent law, but here we focus on, we have some international aspects of this field. And with that, and I want to thank you for being here, for listening. If you have any question, I'm always here to answer. You have here Yanisky-Ravid at fordham.edu. And I really thank you. If you want to watch more videos, so go to these links and enjoy some cartoons from WIPO and from other institutes that explains the things we've learned briefly and can be a great summary. So thank you so much, and see you in court.